Hello, it's Phillip Taylor from Richmond Green Chambers speaking. I'm talking about an interesting case. You can probably just see it. It's called Young versus Bristol Aeroplane Company. It's quite an old case. I've actually got the case in front of me here, and I'm just going to read a little bit out to you because it's a very important case involving the role of the Court of Appeal. The case itself was heard in the Court of Appeal in 1944, and the leading judgment is given by Lord Green, who was then the Master of the Rolls. The facts are relatively insignificant, but let me tell you about them first and tell you why it's an important case. The name itself springs all sorts of things to mind. Bristol Aeroplane Company, think of aircraft and so on. Well, in fact, what it is, it's about a factory. Here, Mr. Young, who was a workman in the factory, Bristol Aeroplane Factory, sustained injuries in the course of his employment because of the failure of the company to fence a machine. So you can think of all sorts of issues, liability, obviously. Mr. Young lost 3 fingers and was unable to return to work for 6 months. And after the incident, the company offered him, and he accepted, a weekly sum of money, and he signed receipts for weekly payments made under an Act of Parliament called the Workmen's Compensation Act of 1925. Now, these sums were paid to him throughout the period of his unemployment. What he then did, he decided to bring an action against the company claiming damages for their breach of statutory duty. So it's primarily an issue in terms of tort. It was found that, as a fact, although Mr. Young could not be said to have exercised his option under the Workmen's Compensation Act of 1925 because he didn't know of his right to elect, nevertheless he'd received the money paid to him by the company as compensation under the Act for losing the 3 fingers. Remember, he's had a contract and he's obviously been injured during the course of the contract. The court at first instance, so we start off in the lowest rank of the High Court, the Queen's Bench Division, they decided that it was bound by the decisions of the Court of Appeal in an earlier case. That's the case of Perkins and Stevenson. And in fact there are other cases, to give judgment against Mr. Young. So he lost. He then decided that the best course of action would be to appeal to the Court of Appeal, and it was put forward on his behalf that the decision in the Perkins case and in another case were inconsistent with the decision in the House of Lords case of Kinneal, Cannell and Coking Coal Limited versus Snedden. So obviously the decision which the Court of Appeal had to decide was whether in fact they were bound by the previous Court of Appeal decision or they were bound by a House of Lords decision. However, the second point that was raised was that in this case of Perkins, the decision was wrong and that the Court of Appeal was therefore not bound by its own earlier decisions, and that's really the crucial point. So the argument was then put to the Master of the Rolls and his fellow judges, and the Master of the Rolls gave a very good judgment, saying that there was no inconsistency between the decision of their lordships in the House of Lords and those of the Court of Appeal in the case which went to the House of Lords. That's the Kinnell case, because there was a different point involved from that decided in the earlier Perkins case. So you can see here that some people may say we're hair-splitting a bit, but the principle that's coming out is the power and the responsibilities of the various courts. The second point which the Master of the Rolls came up with was that the full court that heard this in the Court of Appeal had no greater powers than any division of the court itself. In other words, the power was the same. The third point was that the Court of Appeal is bound to follow previous decisions of its own, as well as those of courts of what is called coordinate jurisdiction. There are, in fact, 3 exceptions to that rule. So you've got the basic rule, and you've got to remember the 3 exceptions, because this is where the examiners love to ask questions. The first one is that it may choose between 2 conflicting decisions of its own. That's the Court of Appeal. So if you've got 2 different decisions, it can choose between the 2 on very similar facts. The second point is the Court of Appeal must refuse to follow a decision of its own which, though not expressly overruled, is inconsistent with a decision of the House of Lords, which is the one higher up court. And thirdly, it's not bound to follow a decision of its own given per incuriam, in other words, as a sideline to the main issue that is being discussed by the court. And it's an important point for one reason. The notes in the law report set it out very clearly. It says there's ample authority here for the statement that in all questions of election or waiver, and this is what happened with Mr. Young, he had the right to elect something. In all those questions, the first matter to be considered is the knowledge of the person said to be having the election or the waiver. And it's got to be shown, of course, that person knew that he had the right to do this election or waiver. And in the workmen's compensation cases, of which there have been many, there seems to have been an established principle that a series of decisions of doctrine of implied election apply. So what the courts are doing is they're digging up the old implied element. And that's always quite a useful device which the judiciary come up with from time to time. Clearly, the issue concerning the workmen's compensation legislation was of primary importance, but the other factor to take into account is the Court of Appeal had considered all the authorities that were put in front of them and confirmed the view that the powers of the full court are no greater than those of a division of the court. So therefore you've got the Court of Appeal civil division, and they're making a clear decision about what they're going to do. There are a lot of cases listed, and they're actually in the judgment itself. And then there's a statement, of course, by Lord Green here on the 3rd of April 1942, which is when the plaintiff, as we then call them, the claimant, had his accident. But the actual judgment itself was given on the 28th of July 1944, so it's some 2 years after the event. It's well worth reading this judgment because many people cite the case of Young and Bristol Aeroplane Company Limited of 1944, and it's always interesting to know what happened and why it's important, because there have been many attempts by many judges to try to find a slightly different way from what is known as the orthodox position. And of course the point about Young is that it's established the law about the powers of the Court of Appeal. Now I say this in the spring of 2009, when come the autumn of 2009 we are going to have the creation of the United Kingdom Supreme Court, and we're going to have all sorts of interesting things that are going to happen at that time. So at least bear in mind our little history timetable of where we are at the present. Good luck with all your studies. Thank you very much. Bye-bye.